we submit they are responsible for the crime of culpable Heineken Berger, the only surviving police officer from that time. Now, all police officers who testified on the first inquest, we submit, perjured themselves to some degree. And former Constable Berger committed perjury in the reopened inquest by making certain false claims on the oath before this court, knowing them to be false. These include the following. The security branch was an elite, even a feared unit within the South African police. This claim that we only learned of security branch torture and abuse committed against political detainees in September 2020, when drawing depicting the injuries on the run. His claim will prescribe. But we've also asked the Lordship to find that Berger lied under oath in the reopened inquest proceedings on certain aspects. We note he chose not to take the court or the family into his confidence on key aspects. He offered a mix of fact and fiction in his evidence, and a great deal of pretense in an attempt to distance himself from the excesses of Haron's treatment. He feigned ignorance of the atrocities committed by the most feared police unit. In doing so, he insulted many South Africans. And my Lord, he treated the court and the family with some contempt. He employed considerable obfuscation in his testimony, when simple answers to simple questions should have been given. He did so, in our view, to minimize, sanitize his own role. However, my Lord, we do not seek a recommendation from your Lordship that he be prosecuted for perjury. Our reasons are set out below. Berger was amongst the youngest and lowest ranking officers at Maitland Police Station in 1969. He was a bit player with no real decision-making authority. We can see there's a certain unfairness in holding a person of such stature as the only person to be held criminally liable in such circumstances. Secondly, if a prosecution is recommended, then there will be an understandable expectation on the part of the family and community that expeditious action will be taken. But in relation to the other inquests dealing with the apartheid era cases, sadly, the authorities have not pursued criminal charges against individuals considerably more culpable than Berger. And these involved actual security branch interrogators who lied under oath about their own involvement in torture. So, for example, in the Timel inquest, more than 5 years have lapsed since the court in that case recommended certain charges against a number of living suspects. We also point out that more than a year has passed since the judgment of the Neil Agate inquest. And again, multiple recommendations were made for further investigation and prosecution on that matter. But, my Lord, lastly, and most significantly, the Haron family do not wish to see him prosecuted for the following reasons. They say that, one, Berger was only a cog in the machine, and the people who should be facing justice are already dead. Two, prosecuting Berger will not bring them any justice. Three, this is the month of Ramadan. They point out that adherents ask for and preach forgiveness at this time. And lastly, they say Berger has his own conscience to live with in his advanced age. Well, Lord, we now turn to the medical professionals, and we've set out in our arguments a great deal of detail of the conduct of the two district surgeons, Drs. Leviers and Gosling, as well as the chief state pathologist of Cape Town, Dr. Schwab, fell considerably short of acceptable standards. It's our view that in conducting their duties in relation to the Imam, they acted with fundamental disregard to the Hippocratic oath they took. In particular, they failed to practice their profession with conscientious and dignity. And with particular reference to Leviers and Gosling, they declined to put the health of their patients their first consideration. In relation to Dr. Leviers, he chose not to protect Haron, not to probe Haron about his illness, as he had a policy not to engage with political detainees or prisoners. He did not take notes of his clinical examination or record the medication he had prescribed. On another occasion, he dispensed medication for Haron without examining him or even talking to him. His physical description of Haron was totally inaccurate and favoured the fabricated police claim that Haron was prone to heart disease. His testimony at the 1970 inquest assisted the police by painting a picture of a man who suffered no abuse. Returning to Dr. Gosling, Gosling failed to ask the security branch members to leave his consultation room in order to conduct a private and confidential medical examination of Haron. Visiting Haron in his cell, Gosling did not instruct the police to absent themselves that he could conduct private examinations. He failed to investigate the cause and duration of Haron's chest pain. He did not inquire that Haron was on medication and when he last consulted with the doctor concerning his chest pain. Turning to Dr. Theodore Schwab, pathologist, Schwab permitted Colonel Pienaar, the head of the security branch in Cape Town, and a potential suspect to be present at the autopsy. He failed to request or arrange for autopsy photographs to be taken. He testified that Haron's bruises were not of a serious nature, even though they covered more than 570 square centimeters of the body, which is considered an injury that requires medical treatment. His histology report was wholly inadequate. He was negligent in not ordering a second toxicology report. Schwar's assertion that the bruises and fractured rib would only cause pain at the time of the trauma for 3 days thereafter was patently wrong. In his testimony, Schwar aligned himself with the police version of a fall down the stairs, even though forensically such a fall could not explain Haron's injury. Now, my Lord, in our view, the conduct of these medical doctors hardly reflects devotion to the service of humanity, as required by the Hippocratic Oath, which is now known as the Declaration of Geneva. Indeed, it is apparent that put the interests of the security branch first, not that of the health of the victim, Haron. They allowed themselves to be manipulated and or intimidated by the security branch in order to limit the damage to the interests of the state. In doing so, they failed to maintain the utmost respect for human life, and they employed their medical knowledge in a manner that was contrary to the laws of humanity. We submit, my Lord, that the conduct of these doctors warrants the censure of your Lordship. In addition, we recommend that your Lordship refer the relevant parts of the record to the South African Medical and Dental Council in terms of Section 45, Sub 2 of the Health Professions Act 56 of 1974, their consideration as to whether the doctors should be posthumously struck from the role of medical professionals. And my Lord, I may just read to you Section 45, Sub 2 of that Act. In our view, it's wide enough for interpretation to ask them to review the conduct of these individuals for possible posthumous removal from the register of medical professionals. It reads as follows: whenever in the course of any proceedings, any court of law, it appears to the court that there is prima facie proof of unprofessional conduct on the part of a registered person, or conduct in regard to such person's profession is unprofessional, the court shall direct that a copy of the record of such proceedings, or such portion thereof, as material to the issue, shall be transmitted to the relevant professional board. We're turning to the legal professionals, Magistrate Krim, Prosecutor Van Graan, starting with Additional Magistrate Krim. Lord, he allowed himself to be used as an instrument of the apartheid security apparatus. His conduct in the first inquest was nothing less than disgraceful. We have set out in particular how he subverted the course of justice. In particular, he prevented counsel for the Haron family from asking questions. He himself failed to ask pertinent questions. He invented helpful scenarios to protect security branch members. He accepted without question the version of the police dismissing the extent and serious nature of the injuries. He refused to entertain medical opinions unfavorable to the security branch. His findings constituted pitiful 4 paragraphs without reasons. And in respect of Prosecutor van Graan, he was, for all intents and purposes, the effective counsel for the police. He displayed no interest in searching for the truth. In particular, he failed to secure the attendance in court of Sergeant AJ van Wyk and Major Kotze, even though they were both involved in the interrogation. He accepted Speaker van Wyk's claims that complaints of torture by detainees were political propaganda. He protected the security branch by submitting to the court that no details of the 3-day extraction should be disclosed. He belittled and dismissed the evidence of Dr. Hellman in respect of the source of injuries without any basis for doing so. Lord, the conduct of Kun and Graan warrants the censure of this honourable court. Look, we note that on 16 October 2003, the name of Advocate Brown Fisher QC was posthumously reinstated in the role of advocates. Lord, we assume that if a name can be posthumously reinstated on the role, it can also be posthumously removed. So we recommend that your Lordship refer the relevant parts of the record of these proceedings to the Legal Practice Council for an investigation of conduct of Kun and Graan with a view to the posthumous removal of their names from the role of legal practitioners. My Lord, we do refer your attention to a statute that was passed prior to that case. It's the reinstatement of enrollment of certain professional practices, Act 32 of 2002. And that statute was relied upon by the court to reinstate Fisher QC. It may be, my Lord, that we will have to press upon the legislature to pass a similar statute to make provision for the posthumous removal from the role of legal practitioners.
Are public prosecutors, except maybe those who are also appointed as ordinarily also registered and similarly are magistrates, except those who also registered.
Lord, as you pointed out,
It seems to me that even to date, we have public prosecutors and magistrates who are not on the list of legal practitioners. Because it seems to me, right me if I'm wrong, but it seems to me that it is not a requirement in the laws of this country for a public prosecutor to be registered with the Legal Practice Council. At best, what we need is the delegation from the Director of Public Prosecution. Similarly, it seems to me that unless you also seek to be admitted as an advocate, you do not require to be enlisted in the LPC as a legal practitioner to become a magistrate. You will subject yourself to the interviews of the magistrates commission. They are satisfied that you are fit and proper. Then if you are recommended to the Minister for appointment. Now if I'm right, it may be problematic for me to make this order.
Yes, my Lord, and in fact, yesterday we drew our attention to the fact that at least in those days, there was not a requirement that prosecutors and magistrates be legally trained. And of course, it's common cause that the LBC was not in existence at that time. So the recommendation that the family wishes to see happen can only happen. It can be demonstrated that one or both of them happen also to be registered with the statutory body, such as the Law Society, the Bar Council. So, my Lord, we do concede that point, and we don't have the information as to whether one or both were in fact registered with such a body. All we can do, my Lord, is to perhaps approach those bodies and see whether historically those registers still survive, and to see whether their names are on that list.
Should the court say anything about the truth in relation of the failure to at least allow the pathologist appointed by the family to make a contribution in the 1970s inquest?
Absolutely, my Lord. And thanks for raising that, because that is another important omission that I dare say all those involved in the first inquest made, not to ensure that that specialist who attended the autopsy provided a report and appeared at the inquest. And that's why we remain perplexed today why, even on the record, there's no suggestion, even from the family team, why that doctor was not called to appear. But certainly it was the responsibility of both the prosecutor and magistrate, once they were aware, as they were, that there was a second specialist at the autopsy, to ensure that he provided a report and testified.
Thank you, Pastor. You're welcome.
As the court pleases. So, my Lord, we ultimately come to our conclusion. My Lord, South Africa's post-apartheid criminal justice system has failed the family of the late Imam Haron. They had to wait more than 50 years for an accounting passed, and hundreds of other families abroad still waiting for truth, justice, and closure. As we mentioned in our opening, the Imam's wife, Halima, she missed this reckoning by just a few years. When the Imam died, Shamila, Muhammad, and Fatima were children. Shamila is now 72, Muhammad is 67, Fatima is 59. They fought patiently for justice, for determination, and dignity. And Lord, this day belongs to them. And the finding of additional magistrate Kun that nobody was to blame for Haron's death in detention cannot stand. It is an ugly stain on history of many judicial frauds perpetrated on the nation. Look, we have demonstrated in these proceedings that the Imam was subjected to vicious and unrelenting torture during its 123 days of detention. After the most brutal period of abuse inflicted during the 3-day extraction, he was specifically denied medical treatment to avoid the obvious signs of his torture being detected. Those involved in the torture who decided to deny him medical attention murdered the Imam. We've asked your Lordship to make that finding. Those at the Maitland police station who were not involved in the torture or the decision to stop him from being medically treated, such as former Constable Berger, but who saw the dire condition of the Imam and nonetheless did not take steps to get him medical attention, they acted with reckless disregard and are responsible for the crime of culpable homicide. Again, we've also called for this finding. The security branch took control of the investigation and invented the story the state case fall in order to explain away the injuries. Corrupt judicial officials in the form of Magistrate Kun and Prosecutor van Graan then dutifully played along this charade. It was the evidence of forensic pathologist Dr. Naidu that, but for the torture and the lack of medical evidence, the Imam would have survived. State medical officers, Drs. Reveres and Gosling, who could have stepped in to save Haron, chose not to do so. They did not do the bare minimum of what was expected of them. Their allegiances lay not with their injured patient, but with the security branch. Then along came state pathologist Dr. Theodore Schwar, a man in our view utterly lacking in backbone and courage. He dutifully massaged his evidence to bolster the obviously false version of the security branch. It was the shameful conduct of these legal and medical professionals that made the dirty work of the security branch possible. As we recommended, not only should they be censured, but as requested by the family, where possible, steps should be taken to positively remove them and enroll their professional registers, should their names be there. Lord, we pause to pay tribute to women and men who stood up in the apartheid state, who suffered terrible abuse and detention. Some of them testified in these proceedings and had to relive the horrors of their torture. Stephanie Kemp, Yusuf Gabru, Shirley Gunn, Robert Wilcox, and Jeremy Cronin. Thank them and salute their courage. In particular, we pay special tribute to Stephanie Kemp, who recently died. Like the Imam, she stood up to tyranny and devoted her life to the struggle for freedom.
Mm.
We acknowledge the incredible and labor-intensive work carried out by the expert witnesses, Dr. Tumaleng Molefe and Stephen Adu, aeronautical engineer Sebastian Woodley, researcher Diane Sandler. They invested considerable time and effort to help us place reliable facts and evidence before this court. We wish to thank Lieutenant Colonel Peterson, the DPCI, for his diligent investigation in this case, for leaving no stone unturned. As counsel, we are deeply indebted to our instructing attorney, Odette Feldenhuis, of the Pro Bono Department of River Winsell, and a team of Mason Samuels and Lisa Marie Dubell. They were towers of strength behind the scenes, my Lord. I should add that Odette really built this case up from ground level, tracing the witnesses. He was relentless in her work. We also thank the Foundation for Human Rights, who stood by party bearer families and supported this case from its inception. We're also grateful to your Lordship for the dignified and methodical proceedings you have proceeded over, and for providing considerable latitude to family members to share their experience and pain. Lord, South Africa is a much poorer place without people such as Imam Haron, Steve Biko, Mapatula Simalani, Amatino, Natiginiwe, Paul Pilata, Wilson Hafferty, Neil Ackett, Ashley Creel, Rick Turner, Dulcie September, Matthews Magalani, and many others murdered by the security branch. They were brutally torn away from their families and communities. Lord, their sacrifices paved the way for our freedoms. In these turbulent times, we could have used their wisdom and guiding hands and take inspiration from their short lives. Lord, on 13 September 2019, Judge Siraj Desai launched an exhibit titled The Life and Legacy of Imam Abdullah Haron, the Dulce September Civic Centre in Athlone. He made this important observation. Ultimately, apartheid was an attack upon the dignity of all of us, and that is what Imam Haron resisted. He was actively involved, non-sectarian, and non-allied, and not allied to any political party. He met the PAC, he met the ANC, and he met the non-European unity movement. He stood opposed against apartheid, and he saw a future in which all of us participated. Imam Haron was a man of irrepressible spirit and backbone. Even while enduring pressures of detention, he was a comforting voice from father to son, with words of solace and strength. Muhammad had a brief exchange with him in the street outside Caledon Police Square. This moment is forever treasured by Muhammad. Haron withstood the inhumanity visited upon him by the thugs in the security branch, civility and dignity. From what we have learned of his character, he probably did so with a twinkle in his eye. This would have enraged his insecure brutes, interrogating him. Haron never broke into interrogation. He betrayed no comrade. He was utterly dependable. The Lord, he endured his final journey, not for himself, but for his comrades and for us. The security branch did crush Haron, the physical man, but they never crushed his spirit. In his last days, he was a shadow of his physical self. His loved ones remembered so well. However, his enduring dignity and humanity remained intact until the very end. Lord, in 1948, the activist and writer Howard Fast reviewed the book Notes from the Gallows by Julius Fouquet. Fouquet had been detained and tortured by the Gestapo, managed to smuggle out his story on scraps of paper before he was executed. As we did in our closing address in the Imam Haron Inquest, we have adapted an extract from Fast's review, which I would like to read out. Like thousands of other prisoners of conscience, Imam Abdullah Haron died so that men and women may be free. In reliving Abdullah's life and struggle, we can only take his hand, which is so strong in death, and thank him. He leaves the world to the living, and the fight he bequeaths us is a fight worth making. Press the hand of Abdullah and every comrade who did their duty and who endured their last battle. Abdullah and his comrades lived for happiness, that they went to battle, that they died. That grief may be connected with their names. The Lord Haron went to his death, knowing that he was on the right side of history. He would have known that his unassuming and steadfast resistance to racial domination posed the greatest threat to his tormentors. He would have known that others would pick up where he left off, and they would not rest until the evil system of apartheid was swept aside. He would have known that his approaching death would ultimately help pave the way for a new South Africa with its enshrined freedoms. His memory is treasured by freedom-loving South Africans. He remains an inspiration to young South Africans working to make a difference in society today. At the Imam's funeral, the writer and poet Victor Wessels, who himself was an activist and had been banned, and he was a member of the unity movement and other organizations. Wessels noted at the funeral, he died not only for the Muslims, he died for his cause, the cause of the oppressed people. Wessels penned a poem as a tribute to the Imam and others who died of detention, at which we conclude our submissions. It's titled For the Fallen. He fell in severed isolation and died alone amongst policemen, unattended by a single friend. A fighter fell. Go tell his death. Go tell. Those are submissions.
Thank you. Mother, I know that 10 minutes into lunch. Like, though I put this claim, that's I not be a big, I'm sure take some time. I really not to trust council when they say they I don't know, take the lunch again. I don't want to be very good at that stuff. Thank you. What against?
All right. How much of it?
Conventional.